indicated that you had some,
Yes, I handed them out. Can I read my letter?
Sure.
I'll clean it up. Mayor Hogan, County Council and Local Media, October 26, 2015. As many of you have heard, I've been dealing with the hornell area concern for youth for some time now. Again, immediately after I took oath as a new alderman in the 6th Ward almost 2 years ago, and it's gotten progressively worse. Although the board of directors of the hornell area concern for youth would tell you they're doing wonderful things for our youth, what I've seen, what the employees have seen, and what my neighbors have seen contradicts what the board claims. I've included a list of complaints we are experiencing in the neighborhood. That list is available, but it's not for young ears or young minds. There's some heavy stuff in there. I have attended board meetings and speak on behalf of my constituents. They usually give me the song and dance about once the center is closed in the evening, it's no longer their responsibility for what the children do in the neighborhood. They have told me they have guidelines and punishments for those kids that break the rules. That is all well and good, but the facts remain, whatever they are doing is not working. If poor management and properly trained employees and temps are the foundation for a successful business, then they take the cake. Nothing spells disaster when walking into the center to attend a board meeting and seeing two young teenagers laying on top of each other on a couch as a 9-year-old stands there watching them kiss. I emailed the chief of police on September 24th of this year for a list of all police calls involved with the hornell area concern for youth. I have received nothing. I've called the chief numerous times, including this morning, asking again for his assistance with this list, so I can bring this list to you at the meeting and show what really goes on. Still nothing. I've talked to the patrolmen at the station. They agree with me that the center is, and I will use their words, a hole. Another troubling aspect of this is that I found out that they were given permission to operate as a business as long as they made some changes to the facility to make it compliant with the law. A variance was issued back in 2005. I may be incorrect on that date, but it was back then. To this date, they still have not brought up to compliance. A neighboring resident has made a formal request to the city of Hornell to have the Hornell area concern for youth shut down on the basis of non-compliance. The city attorney has submitted his opinion on that matter, which is in our packets, and I have to formally disagree with it. According to the city attorney's position, if this is the city, how the city does business, by requiring businesses to do certain things to come into compliance, then years after the business shirks that requirement, and the city comes back and says, well, the city is no longer responsible. That's a problem. That makes no sense to me. And I think it sets a bad precedence for the next business owner somewhere else. Furthermore, the Hornell Codes report that we received in our packets, I would like to know that the codes officer informed the Hornell area concern for youth that they must come into compliance on this matter. So there's conflicting sides of the codes are saying they need to get up to the compliance, and our city attorney is saying it's not the problem. Respectfully submitted and advanced. Thank you. I also have a couple of members of my ward who would like to speak today. County Mark Darcy are here. Permission for them to come forward.
Fine, yeah, go ahead. You can give me my cap.
So, we had formally requested from Mr. Burdette as well as the mayor and to the city attorney that we'd like to see a stop work order served on the Hornell area concern for youth because of multiple violations of code. We feel that the initial use variance was given properly. We have seen Mr. Pelton's opinion on that, and whether or not there is something that can be done because of statute of limitations, it still was improperly done. Aside from that, the certificate of occupancy should never have been given. The use variance was predicated on the idea that they were going to add, they're going to have at least 6 parking spots. They never did that. They were supposed to put some parking behind the building. They never did that. They put planting beds in the location on their map. They said they were going to put parking. They were in willful violation of their use variance, and they did this for 10 years. Code 31538.f, or the Hornell City Code, says that in the case of a variance issued by the zoning board, If that variance hasn't been undertaken within a year, then it's really null and void. So even if we can't go back on the statute of limitations, the idea is that they voided their own variance by not coming into compliance. So the variance doesn't exist at this point in time. The code enforcement officer told them that they had to come into compliance. We have some issues with the initial parking plan that was even submitted and approved by Mr. Hagan back in 2005. They were granted use variance and not an area variance. So to make changes to the property, including putting parking in the back, would have required an area variance, not a use variance. So the use variance allows them to use that property, but they would need an area variance to make changes to include that parking. That was not part of the variance that was given. We also contend that the off-street parking plan that they submitted was not an accurate representation of the property. Some of the parking that they say exists along Emmett Street does not fulfill city code as far as the size of the parking spots. When they're parked in the one spot, which is number 4 on their map, any car extends over the sidewalk. So it blocks the sidewalk, which is both a city code violation and a New York State B&T violation. So it's both a code violation as well as a possible ticket. We were discussing this one day with Dan, and he called the police and asked them to come down and look into it. And we were told, what the officer told him that you're putting them in a bad spot. I don't understand it. I just don't understand it. I don't understand how an organization that willfully violates what is really a contract with the city is just given a free pass.
Well, let me try to address some of those issues. I'll have Joe. I'll tell you what I know. In 2005, when they moved from Seneca Street to that location, first of all, let me clarify, Concern for Youth is not a city agency. It's a 501c3, an independent corporation with an independent board.
It is funded by the city.
No, we give, they have a budget far exceeds anything. We give them $30,000 per year, and we have done that for probably 20 years. And that assists them to, to use that to obviously apply for other funds. But they're funded through various school districts, the State Office of Mental Health. So it's not a city agency. It has nothing.
They're also funded by the individuals by somebody that has them plant that garden, right? The garden spots where they put.
Well, I assume that was part of some grant that they received or nothing. I don't know. We don't, it's just like the public library. They have an independent board. They're not-for-profit. We give them money, but we're not responsible, nor do we condone what goes on there. And I appreciate your research and everything else. I got an email from you with all that there. I forwarded it to the city attorney. I'm not a lawyer, nor even purport to be one. The city attorney took what you gave him, and he responded to that in kind to me, and I shared it with the Common Council, and I shared it with you in Concern for Youth.
But I think that only is a response to our first point in the 5%.
Yeah.
It's only a response to whether or not it was a valid.
Well, right, and the thing is, I can give you 2 hours to this body. There's nothing we could do here for you in that situation, unless, if we take the $30,000 away from Concern for Youth in next year's budget, that's about the only action that we could take.
Who directs the code?
Well, the code does, and the code has been working on it, and the code was working on it, and it said, be patient, we're gonna get this resolved. And next thing I know, yeah, and the next thing I know, we're getting the email saying, threatening litigation and stuff like that. I send it to the city attorney. The city attorney responds. I thought that the issue was being worked upon, and I had spoken to the president of the board, Marie Labanowski, and I said, we got to get this worked out. You got to, this has got to be resolved. Because I understand there's been issues down there. Not this past summer, but 2 summers ago, we had to put police patrols down there. I'm not oblivious to some of the issues that have gone on down there, but I can't sit here and answer for the zoning board of appeals. I can't answer for the zoning officer who approved it, who hasn't worked for us in 10 years. You know, so you're raising all these issues, which we will address, and we'll address them legally, but when I get an email threatening further legal action,
We didn't say we were going to take legal action. We said that we would do anything within legal means. That means we're not going to do anything illegal to remedy the situation.
well, fine, and
In the emails, if I remember correctly, you were the first one to say something, no, Dan said something about litigation, and then you said something about everybody deserves a day for
Right.
every day in court.
right.
We didn't bring up any of that, and our last line in the email is not meant to be a threat of litigation.
This
We were
says,
saying-
well, can I read it? Because I
Coming here-
have the email here. Can I just read it? As such,
Yep.
this is the last sentence, as such, any delay in action regarding this request will force us to explore any and all legal means at our disposal to remedy the situation.
Exactly. Yes, and I'm saying that I mean that by the, I'm not gonna do anything illegal to try to get them out of there. This is a step. We came here to try to make this a more public issue. Because there's a problem. There's a problem. And I think you could go there and say, you willfully violated your use variance for 10 years. Here is a stop work order. That is something that codes to do now.
What, in the essence, the stop work order is that you want us to shut the organization down.
Yes.
Yes.
Well, I don't think, I don't think that, we will, entertain that, motion, or entertain that thought, because I don't think we have the ability to do that,
Mr. Mayor, if
Joe.
there was any other business in the city that are willfully violating an order, it would be shut down.
Oh, I can list many instances, Mr. McManus, one which you used to work for.
Right, it was shut down.
After how long?
No, that was never shut down.
No, it was never shut
You weren't allowed
down.
to serve lunches, and you weren't allowed to occupy a certain part of the
We're not,
board
we're,
that
what
there
I'm
was
saying
supposed
is,
to be
even
a
playing
law.
field, that man went to court. He was shut down. We
Well-
could not use that room, remember?
His business was not closed, his expansion, which was.
We had to stop
They
work order.
wouldn't close their business. They have a second location in Kansas City.
Time out.
No,
Here's the thing. I've got a couple of questions. Where were you 10 years ago when these permits
I
were being
wasn't-
issued?
I wasn't
Let me
living
finish,
in the house.
please. Can I finish?
Sure.
Where were you 10 years ago when these permits were being issued and the statute of limitations was taken? Why didn't you come forward then and voice your concerns and your objections?
Because you did not properly notify anyone that there was going to be a hearing. It wouldn't have been possible.
The hearings were
It would
noticed.
not have been possible considering the fact that the youth center did not provide their application until June 14th of 2005. And in your letter, you state that it was approved in June 16th of 2005, which is 2 days. You're required to give 5 days public notice.
Well, the answer is, it's very simple. The
Yeah,
complaints
something's wrong.
that I read in this correspondence deal with you or neighbors against individuals. It's not the function of government to act as a sword to go after private individuals for their conduct. If there's a problem between two neighbors, then the two neighbors should get their respective lawyers and litigate the issue. It's not the city of Hornell's function, and it's an improper function to get embroiled in such situations. I'm sorry. Now, if you feel that that permit was issued improperly, then sue us. It's very simple.
Right, that's antagonistic.
Well, no,
That's
that's
antagonistic.
what you want us to do.
I want the code enforcement to go there and say, this was a willful violation for 10 years
If there's a violation of the law,
of the code.
And of New York State Fire and Building Code.
well, if you,
Which was brought to your attention, which there is no statute of limitations on.
I have nothing to do.
Yeah, we're,
Just speaking of the variance, I served on the ZBA years ago, but it was that and that. And I served for probably a couple years before I went to council. As far as the issuance of a variance, the ZBA, correct me if I'm wrong, correct me if I'm wrong, but once a variance is issued, once the ZBA decides on a matter, they are, in essence, a court of sorts. That has legal standing that can't be undone by the mayor, can't be undone by the council, can't be undone other than going to the judge. Is that
You can
correct?
you have 4 months to go to the judge under the CPLR to dispute the issuance of that variance. Once that 4 months is expired,
So if
That's-
it's 4 months is expired, you have free reign to do whatever you want. The variance requires in its statement that 6 parking spots be created and maintained.
well, I think.
They were never created
But
nor
I
maintained.
think what we're trying to say is, you instigated this, the legalese. We're trying to I was working with the codes office and the board, trying to work that thing through. And we said we were going to engage you in conversation, and you said, well, why do we have to talk about it? So if you have your mindset on a legal solution to this, then Joe was right. You have to,
We tried to talk to the board. We tried to be cool when we first moved in there. We tried.
What- and
so
how long-
many-
yeah,
we tried
yeah,
so many different
yeah,
things.
right.
And it just, nothing has ever worked.
Well,
It is a nightmare.
yeah.
If you have it next to your house, it devalues our property
Right.
and it reduces our quality of life.
No, I understand that, and I understand it, and I think, and I don't know what we can say. We can't, as a common council, undo what's been done. So, and you put a public face on it, it was great, but we can't, I'm just telling you, we can't do anything that's been undone. I can remove funding from Concern for Youth, that's the only thing I can do, or this body can do. And so, unless we can reach an amicable solution between the Concern for Youth, you and the neighborhood, because you're not the only one. You happen to live next door to them, but there's been others, and please, I'm aware of it. We've tried to, and we understand there are some issues down there, and we've tried to deal with them. Now, this issue specifically on parking, is that the main issue, or is it the issue you just don't want it there?
The main issue is that they're not following procedures and
Okay, but is just the legalese that you think is the silver bullet? Oh, well, right. I'm not saying anything. Yeah, well, I just think you're here. Let's bring the Concern for Youth here and put a public face on it. If you think that'll do any good, and give them a,
last week in the Kansas City paper.
well, yeah, well, I just think that, you're bringing up incidents that happen in another community, and we are aware of incidents that have happened. To condemn the whole organization, that have a volunteer, unpaid board, and that have done good work over the years, is not appropriate. If there are issues down there that have to be dealt with, we will force the issue as much as we can. And the carrot we have is $30,000. But if it's just the parking situation, if that's just the tip, and there's a whole lot of other problems under that iceberg, well, then that's what we need to know. So that's the question I'm asking.
The
So,
reason for this is because it is the foot in the door to make this a public issue. Because it's a problem.
Well,
It's a problem, so this is
Well,
something
well,
we need to do
well, then-
that would make somebody pay attention.
Yeah.
Because when we call the police, we get brushed off.
let me
You know,
ask
when
you
they-
a question about that. Excuse me, I want to interrupt. Let me ask
Yeah.
you, when you call the police, did you have a specific complaint? Did you say, I want to file a complaint against so-and-so for violating the law? And if you did you do that? And if you did that, you said, I want so-and-so arrested for this specific thing. And did the police then fail to react?
We asked them to, Mechanics was And